Stop for just a moment before assuming your family's future is already protected. One of the most expensive estate planning mistakes isn't making a bad investment, losing money in the stock market, or forgetting to write a will. It's a single piece of paperwork that millions of people never complete because they don't even know it exists. That tiny oversight can quietly undo years of careful planning. Parents spend decades working hard, saving every month, paying off debt, building retirement accounts, buying life insurance, and putting money aside so their children will be financially secure after they're gone. Yet when the time finally comes for those savings to be passed on, some families discover that the process is far more difficult than anyone expected. Instead of receiving money quickly, they face months of waiting, stacks of legal documents, unexpected court procedures, and bills that continue to grow. In larger estates, those costs can add up to tens of thousands of dollars, reducing the inheritance that was meant to help the next generation. Even more surprising is that many of these delays happen to families who believed they had done everything right. They had a will. They thought their planning was complete. But there was one missing detail that changed everything. The truth is that certain financial accounts don't always follow your will the way most people think they do, and this misunderstanding catches families by surprise every single year. While loved ones are already dealing with grief, they are suddenly forced to navigate paperwork, legal processes, and financial uncertainty that could often have been avoided with just a few minutes of preparation. That's what makes this mistake so frustrating. It isn't usually caused by carelessness or lack of love. It's caused by a lack of awareness. Very few people are ever told about the simple form that can make a major difference, and because nobody mentions it, millions continue making the same costly mistake. In today's video, you'll discover what this free form is, why it can be far more important than many people realize, how it works behind the scenes, and why financial experts encourage families to review it regularly. You'll also learn the common mistakes people make when filling it out, why outdated information can create serious problems years later, and why simply having a will does not always guarantee that your money reaches the people you intended without delays or unnecessary expenses. We'll also clear up several myths that confuse even smart, financially responsible people, and we'll walk through a realistic example that shows exactly how one forgotten document can change the outcome for an entire family. Most importantly, you'll leave with a simple checklist that can help protect your loved ones from unnecessary stress and possibly save them a significant amount of money in the future. The final part of this video is especially important because we'll cover one mistake that many families don't discover until it's too late to fix. And knowing about it today could spare your children months of frustration later. Welcome to the channel, where we break down complicated financial topics into simple, practical advice that helps you protect what matters most. If you enjoy learning ways to make smarter financial decisions and avoid costly mistakes, make sure you subscribe and turn on notifications so you never miss another video. Now, let's get started. Most people believe that once they have signed a will, every dollar they own will automatically go exactly where they intended. It sounds logical, and that's why so many families never question it. But this is where one of the biggest misunderstandings in estate planning begins. A will is an important document, but it does not always control every asset you own. In fact, some of your most valuable financial accounts may follow completely different instructions. Retirement accounts, life insurance policies, many investment accounts, and even some bank accounts often rely on a beneficiary designation instead of your will. That means the financial institution first looks at the beneficiary form you completed when you opened the account or updated it later. If that form names a beneficiary, the institution usually follows those instructions. If the form is missing, contains outdated information, or names someone you no longer intended to receive the money, the situation can become far more complicated than most people expect. A surprising number of people never update these forms after major life changes. They get married, divorced, have children, lose a spouse, or experience other important events. Yet the paperwork remains exactly the same for years or even decades. In some cases, people don't remember whether they filled out the form at all. Others assume their will automatically replaces anything written years earlier. Unfortunately, that assumption can lead to unexpected results because beneficiary designations often take priority for the accounts they govern. That means money could legally go to the person listed on the beneficiary form, even if your will says something entirely different. This catches families off guard every year and often creates confusion at the worst possible time. When there is no valid beneficiary designation for an eligible account, or when other assets must be handled through the legal system, another process begins that many people have heard about but few truly understand. It is called probate. The word itself sounds complicated, but the basic idea is actually simple. Probate is the legal process used to settle a person's estate after they pass away. Before property can be distributed, the court usually confirms that the will is valid if one exists, identifies the deceased person's assets, notifies creditors, ensures legitimate debts and taxes are addressed, and oversees the legal transfer of remaining property to the rightful heirs. Sometimes probate moves smoothly and finishes without major problems. In other situations, especially when paperwork is incomplete, family members disagree, or the estate is more complicated, the process can take many months or even longer. During that time, loved ones who expected immediate access to certain funds may find themselves waiting while legal procedures continue. Bills still arrive. Daily expenses continue. Mortgage payments, medical costs, education expenses, and household responsibilities do not stop simply because an estate is still being processed. For families already dealing with the emotional pain of losing someone they love, the waiting period can become another source of stress and uncertainty. Many people also underestimate how expensive this process can become. The cost is not usually caused by one large bill, but by many smaller expenses that gradually add up. There may be court filing fees, attorney fees for legal guidance, executor or personal representative costs for managing the estate, administrative expenses for handling documents, appraisal fees if property or valuable assets must be evaluated, accounting costs, and other professional services depending on the situation. Every estate is different, and the exact amount varies widely based on state laws, the size of the estate, and how complex the assets are. Some estates move through probate with relatively modest expenses, while others can cost thousands or even tens of thousands of dollars before everything is settled. But the financial cost tells only part of the story. The hidden cost is measured in time, uncertainty, and emotional pressure. Family members may need to make repeated phone calls, gather financial records, attend meetings, complete legal forms, and wait for approvals while trying to cope with grief. Small misunderstandings can grow into disagreements. Questions about money can create tension between siblings who normally get along well. Adult children who expected a straightforward process may suddenly find themselves dealing with legal matters they never anticipated. This emotional burden often becomes just as difficult as the financial expense. The encouraging news is that many of these problems can be reduced, and sometimes avoided altogether, through a very simple step that costs nothing at all. Many banks, brokerage firms, insurance companies, and other financial institutions allow account owners to complete a beneficiary designation. Depending on the type of account, this may also be called a payable-on-death, or POD, designation for certain bank accounts, or a transfer-on-death, or TOD, designation for certain investment accounts and eligible assets. Although the names sound technical, the purpose is straightforward. You simply tell the financial institution who should receive the money or assets after your death. The form is usually short, often taking only a few minutes to complete, and in most cases there is no charge for filing it. When properly completed and accepted for an eligible account, it allows the institution to transfer that specific asset directly to the named beneficiary according to the account agreement and applicable law. Instead of waiting for the entire probate process to finish before that particular asset can be transferred, the institution can generally follow the instructions already on file, provided everything is valid and up to date. Some people hesitate because they worry that adding a beneficiary means giving away ownership of the account while they are still alive. That is not how these designations normally work. You remain the owner of your account for your entire lifetime. The money is still yours. You decide how to use it. You can deposit more money, withdraw funds, invest differently, or even close the account if you choose. You can also change the beneficiary whenever your circumstances change, provided you follow the institution's procedures. If you get married, welcome a new child, experience a divorce, or simply want to name someone else, you can usually update the designation. The beneficiary has no ownership rights during your lifetime simply because their name appears on the form. Nothing changes until after your death. At that point, The financial institution reviews the beneficiary designation already on file and follows those instructions for the eligible account if everything meets the legal requirements. This is why keeping the form current is so important. A document completed years ago may no longer reflect your wishes today. Despite how simple the process is, people continue making the same avoidable mistakes year after year. The first and perhaps most common mistake is never naming a beneficiary at all. Many people leave the section blank because they plan to return to it later but never do. Others believe it is optional and decide to skip it entirely. The second mistake is failing to update the designation after major life events. Life changes constantly, yet paperwork often remains frozen in time. A person who was the obvious choice 20 years ago may no longer be the person you want to inherit today. The third mistake is believing that a newer will automatically replace an older beneficiary form. This misunderstanding surprises countless families because they assume the most recent legal document always controls everything. For many eligible accounts, that is simply not how the process works. The beneficiary designation often determines who receives the asset. Another mistake is naming only one beneficiary without choosing a backup, sometimes called a contingent beneficiary. If the primary beneficiary dies before you and no backup has been named, the transfer may become much more complicated than expected. Finally, many people complete the paperwork once and never look at it again. They regularly update their phones, passwords, streaming subscriptions, and insurance policies, yet they never review the documents that may control some of the largest financial assets they own. A quick review every few years or after a major life event can prevent serious problems in the future. To see how easily this situation can develop, consider the story of David. He worked hard throughout his career, saved carefully, purchased life insurance, invested for retirement, and even hired a lawyer to prepare a will. He believed every detail had been taken care of. Years passed, and life became busy. His investment account paperwork stayed in a file cabinet untouched. David assumed the will would handle everything because it clearly stated that his daughter should inherit his assets. After his death, however, the family discovered that one important investment account did not have a valid beneficiary designation on file. Instead of transferring quickly, that account became part of a longer legal process. His daughter waited while paperwork moved through the system. Professional fees reduced the amount eventually available to the family, and a process that David expected to be simple became much more stressful than necessary. Nothing about David's intentions had changed. He wanted his daughter to receive the money. The problem was that one overlooked form stood between his wishes and a smooth transfer. Had he spent just a few minutes updating the beneficiary designation while he was alive, that specific account could likely have been transferred much more efficiently. At the same time, it is important to understand that beneficiary forms are not a complete solution for every estate. They are powerful tools, but they are not designed to solve every planning challenge. Not every asset can use a POD or 2D designation. Rules differ from one state to another, and financial institutions may have different procedures for different types of accounts. People with large estates, complicated family situations, business interests, significant real estate holdings, or special planning needs may benefit from additional legal tools such as trusts or other estate planning strategies. This is why reviewing your overall estate plan with a qualified estate planning attorney can be a valuable step. The goal is not simply to complete one form, but to make sure every important document works together and reflects your current wishes. Fortunately, checking your own situation does not have to be overwhelming. Start by making a complete list of every financial account you own, including bank accounts, retirement accounts, investment accounts, life insurance policies, and any other valuable financial assets. Then review each one to see whether a beneficiary has been named. If a designation already exists, confirm that the information is still accurate and reflects your current intentions. If your family has changed because of marriage, divorce, the birth of children, or the loss of a loved one, update the paperwork as needed. Whenever possible, consider naming a backup beneficiary so your plans remain protected if circumstances change unexpectedly. Finally, keep copies of your important documents in a safe location where your family or trusted representative can find them when they are needed. These simple steps require very little time today, yet they can make an enormous difference for the people who matter most tomorrow. As this video comes to an end, one message is worth remembering above everything else. Most parents spend years, even decades, working hard to build a better future for their children. Every paycheck saved, every investment made, every financial decision is driven by the hope that the people they love will be protected long after they are gone. But sometimes the greatest risk isn't a market crash, a poor investment, or an unexpected expense. It's a simple piece of paperwork that never gets completed or updated. That small oversight can create delays, confusion, unnecessary legal costs, and stress for the very family you wanted to help. The good news is that this is one of the few financial mistakes that can often be prevented with just a little time and attention. Taking a few minutes today to review your beneficiary designations and other important documents could save your loved ones months of frustration and, in some cases, thousands of dollars in avoidable expenses. More importantly, it can give them something that's impossible to put a price on: clarity and peace of mind during one of the most difficult times of their lives. The true value of estate planning isn't measured by how much money you leave behind. It's measured by how smoothly that money reaches the people you intended to protect. A well-prepared plan becomes one final act of care, making life just a little easier for your family when they need it the most. If this video helped, you learned something new, don't keep it to yourself. Share it with your parents, your children, your spouse, your relatives, or a friend who may never have heard about this important step. One simple conversation today could save a family from major problems in the future. And if you enjoy clear, practical advice that helps you protect your finances, avoid costly mistakes, and make smarter decisions for the future, be sure to subscribe to the channel and turn on the notification bell so you never miss our upcoming videos. If you found this information valuable, give this video a like because it really helps us reach more people who can benefit from it. Thanks for watching. Take care of yourself and your loved ones, and we'll see you in the next video.